Today we're going to be talking about what is the amount of case analysis necessary in different situations. And then we're also going to be talking about the difference between primary and secondary authority and mandatory and persuasive authority as well. So I talked about this in the course overview, but if you don't watch the course overview, remember there's an extra credit opportunity. If you fill out your course surveys, that you'll get an email and you forward me the confirmation email. So after you do the survey, you get a confirmation email from Harper. Forward that to me and I'll give you 5 points extra credit. So get that in at the same time or before you get in your final paper. Okay, so a lot of people, when they're first starting out with legal research and writing, they make the mistake of doing just like vomiting up things from a case, doing a direct quote, and then that's it, without any analysis at all. So if you just kind of like have a quote with your case cite and without describing the factual context of the case, it's really not enough. You're asking the reader then she's going to have to pull the case herself and analyze them and to see if you're taking it in or out of context. So it's really like inappropriate to do this kind of writing unless, it's a very often described point of law, like summary judgment should be granted when there's no genuine issue of material fact, or just something very, very simple. Now, the use of string cites would be you'd have like a quote or a statement of law, and then you'd put not just one case that stands for that proposition, but multiple cases. They call that a string cite. And you use a string cite when we're talking about something like this is so obvious that like every case says this. So you're trying to say that this is a well-established point of law. So that's when it's appropriate to use a string cite, but you don't really have to use them. And then these little incomplete analysis, like just quoting something without talking about what the case is, really only do that if it is a clearly established point of law, or so do that. But and then you can only use the string cite if all cases really stand for that exact stated proposition. And make sure if you're doing a string cite that they're all from your jurisdiction, not just like this is what the law is throughout the country. So conclusory statement. So you're making a conclusion that a concept applies. You're going to need some basis, like similar facts, that the cases are somehow similar to what your fact situation is. So I would maybe do these you could use that kind of like brief conclusory stuff if it is a minor issue in the case. Demonstrative, that's the statement that holy cow, my phone's exploding. Statement of a conclusion. This is your real severe case analysis. And this is really, in each section of a brief, you might have one or two cases that you do demonstrative case analysis, where you're going through, talking about the facts of the case, you're going through the elements of this point of law, and talking about what the holding of this case is with relation to your factual situation and your legal issue. And you need that for these major issues. So especially think about in your final paper, you want at least one case in each of your sections that have this demonstrative case analysis. Exhaustive case analysis. is, if you only have one case, you can do this. So you're really like almost adding a case brief into your writing. You really don't need to get this crazy unless really this is the one case that you are going to be discussing in your legal writing. When you're trying to determine how long a legal writing should be, it depends on the situation. What assignment have you been given? If the attorney comes to you and says, I want something by this afternoon, well, it can't be that long, can it? Because you can't write a lot in this afternoon. But if they say, I'm going to give you 2 months to do it, maybe they want something longer. You can specifically ask how long you want it to be. So, that's how long you have. And then like the tolerance of the reader, judges don't want an appellate brief on every motion. They want you to just get to the point and get your brief done. So, when you're doing your reading, you should make sure you're telling the source of the law, how it applies, the steps you went through to get to it, and all like relevant applicable law. Other things you think about is your duty of advocacy if you're writing to the court. How much do you need to how much research, how much length, how much electronic space do you need to state what you're arguing for your case? Remember, any major case, you want to go in depth in this, like, full analysis, and then conclusory analysis for the minor cases. And then remember, just like we're doing in our final paper, if you're writing a brief to the court or working on that, you want to anticipate what the other party might argue and get that, kind of get that out of the way. So the judge doesn't think that you are blindsided by this argument and didn't consider it. So you can say, well, someone might argue blah, 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 and here's why that's not right. So you get it out of the way and, spend a little less time on it, but get it out of the way so that the judge doesn't think you're afraid of it and understands your argument from the very beginning. Okay, make sure, don't do this vomiting. Okay, I hate it when people just like cut and paste an entire paragraph out of a case without any explanation or interpretation. It's just lazy, and it means that you don't understand it. Don't make any statements without support. String cites, I don't think they're necessary for you. And if it is an important issue or an important case, use that full analysis. And at least really for each issue, make sure you're looking at, a point of law, whether it's a case or a statute, at least one per section. Make sure you're looking at that counter analysis. Make sure you're looking at the argument from the other side, even if you're doing both in persuasive writing and in predictive writing. All right, so let's talk about authority. I'm thinking of the John Mellencamp Authority song. But authority is anything that a court might use to make a decision. Okay, so for primary authority, that's what we've been concentrating a lot on this whole semester. That's really a law. Primary authority is a law that the court may rely on. Okay, so a case, a statute, an administrative regulation, a treaty, things like that. But for primary authority, you're going to have two different grades of primary authority. You can have mandatory authority, which is if you cite this, a court has to rely on it. So, for example, a statute in the jurisdiction where the court sits, right? They have to follow that. That is mandatory authority on a court. Or a case of a higher jurisdiction. Court has to rely on that decision. It doesn't have the leeway, the wiggle room to change that law. Now, the other gradation of authority would be persuasive authority. So persuasive authority is any law that a court may rely on. So if I am the Illinois Supreme Court and there is a decision from the Illinois Appellate Court, that's what we call persuasive authority. So the Illinois Supreme Court can choose to not rely on that Illinois Appellate Court case because they are a higher court, but it is persuasive to them that this is a court in their jurisdiction who rules in a certain way, and they usually will follow that. Now, say someone cites a case in Wisconsin from the Wisconsin Supreme Court. That, again, is persuasive authority. Court doesn't have to follow it and would be much less likely to follow it than something in the same state. So there's different gradations of persuasive authority. Some authority is more persuasive than others. Excuse me. Now, our secondary authority is non-law that a court may rely on. And secondary authority is always persuasive because it's not a law. But things that courts may use when making a decision would be like when you're trying to find out the common meaning of a word in a statute. They often look to the dictionary definition. Okay, so that is non-law that a court relies on. It might be a restatement that hasn't been adopted yet, or it might be a law review article. So it doesn't even have to necessarily be related to the law. It might be something like a thesaurus or a dictionary or something along those lines. Now, non-authority is something that a court cannot rely on. So, for example, a case that isn't on point, like a criminal case in a civil litigation, a statute that's been held unconstitutional or has been repealed, something like a digest or Shepherd's, that's a book that's just a finding aid. So those aren't authority at all on a court. So for a statute to be mandatory authority, it has to be in the appropriate jurisdiction. So if we're in Illinois state court, then it would be an Illinois statute. If I'm in Illinois federal court, it would be, the U.S. code, the U.S. statutes. So the appropriate jurisdiction is key first. And then the intention of the lawmakers that the law cover this set of facts. Okay, so you look through the words of the statute, you look through how it's been interpreted, maybe you look through the legislative history to say, did the lawmakers think that this should apply in this certain situation? A statute cannot be mandatory authority if it violates a higher law like a constitution. Okay, then it is not a mandatory authority. And, 99% of the time, a statute in your jurisdiction is mandatory authority. Now, you may remember back to the beginning of the semester when we were reading the Peterson case that Drew's law was found to not be mandatory authority on the courts because it was kind of like a court rule which that court found was should properly left to, the courts can rule themselves on procedure. So that's kind of a chink in that one. For case law, it has to be right on the same issue, right? It has to be on point by a higher court in the appropriate jurisdiction. So if you go to the Stasky book, again, I'm sorry, I don't have an electronic version of the Stasky book, but on page 163 or 160, 163 it starts. If a higher court is reviewing a lower court, it doesn't have to follow it. And we're assuming we're in the same jurisdiction. And a lower court has to follow the decision of a higher court. If it's the same court, so say I'm on the Illinois Appellate Court and I'm looking at a prior opinion from the Illinois Appellate Court, it's not mandatory, but it is strongly persuasive. They will usually follow it. And in different jurisdiction, again, that's not mandatory authority. That is only persuasive. It does not have to be followed. Okay, so for it to be, it has to be same issue, higher court, same jurisdiction. With regard to what wins state versus federal law, it depends on the law that's being interpreted. If you're interpreting a state law, then state courts have the final say. If you're interpreting a federal law or a constitution, the U.S. Constitution, then federal courts have the final say. For persuasive authority for case law, if the case is, similar, they may look to non-mandatory case law to make their decision. Places they would definitely look would be a lower court in the same jurisdiction or in the same level court. It's really unusual for a court to rely on case law from a different state. So really, it's not your job to do that unless instructed to do so by an attorney. A court would only rely on that if there's no case law on this issue in a state, and they'll call it like a case of first impression in this jurisdiction. Okay, so this was the case that I had come out right before I started practicing law, called Smith versus Eli Lilly. And Eli Lilly was a manufacturer of a drug called diethylstilbestrol, or DES, which was given to women in the 50s and the 60s for morning sickness. And it ended up that some of the babies had problems with their reproductive organs later in life when they grew up. So when they were trying to figure out, 20 years after the pregnant woman had taken these drugs, they had to figure out, well, who actually manufactured this drug? It's not like when you take a pill that is the same, you don't really look to who the manufacturer was. So Illinois, if you can't figure out who manufactured it, maybe you couldn't bring a lawsuit. So this was kind of an issue in the 90s. And in California, they had come up with this theory called market share liability, which said that if you bring in all of the potential manufacturers of this drug and you find liability, each of these defendants would be responsible to pay the percentage that was their market share at the time. So in Smith versus Eli Lilly, which was in Illinois, the plaintiffs, on appeal, tried to bring this theory before the Illinois Supreme Court to say, we should adopt market share liability. And then you're looking at these persuasive cases because they're not in the same jurisdiction. Long story short, Illinois did not adopt market share liability from Sindel versus Abbott Labs. So anyway, so persuasive authority, any secondary authority is going to be persuasive. I would not cite secondary authority like a law review. I wouldn't do that in a legal brief. It's kind of lazy, and you're really only going to use secondary authority as a way to get to the real law. So that's kind of all I have for today. Don't forget to keep working on your paper. Look at the calendar so you're not missing any dates, because I'm not going to be really checking in with you too much. I think this week you'll be making appointments to meet with me the week after Thanksgiving. So I look forward to meeting with you individually, and please feel free to reach out if you have questions for me about the paper or anything else for the class.